Based upon the content of the program, I want to make sure we all know our goal is effectively to identify some of the basics of HIPAA requirements for patient records and privacy. HIPAA privacy violations involving social media, which is all this is what about, and employment and human resources policy violations also involving social media, and some issues of state licensure laws as applied to HIPAA privacy violations involving social media. Let's see. Let's move on to the next, please. Some disclaimers here. I think it's appropriate that we all know what we're here to cover, and I hope this is going to be very helpful and a very worthwhile use of our time. Some of the goals of the content of the program, what this does and does not cover. This does provide a broad overview of HIPAA confidentiality issues in social media. It does not cover everything about HIPAA or as HIPAA is applied to any specific healthcare profession. You could probably have a days-long training session on HIPAA, or you could do an hour or two on HIPAA as applied to any specific healthcare profession. But I hope we cover the basics because social media stuff is are problems that cut across every healthcare profession. It's just not what dentists encounter or nurses or social workers. Why are we here? Why, I hope it educates the person attending to ask the right questions in their own state, if their own healthcare facility employs them, their own medical office, and in their own profession about compliance with HIPAA confidentiality and what employment policies and laws may apply to healthcare practitioners that can be violated by the misuse of social media. I do want to say many thanks because some of this content was co-developed with Stuart Showalter from San Diego. He's the contributing editor of Healthcare Financial Management Association, and we appeared with a column that covered on some of these topics in the Legal and Regulatory Forum of the February 2018 Healthcare Financial Management Association newsletter. So this is otherwise very ripe content that I've taken and built on to a full 60-minute webinar. So I want to go back here because there's a point on the screen here. Just look at what we want to cover because we know about patient records and privacy. We'll skip through that a bit. We'll talk in detail about social media. Employment and human resources policies and state licensure laws. You know, you have to keep your eye on the ball with this topic, but me as a lawyer and with my experience and background, it helps to have a broad perspective on these things, and that's the way I help healthcare professionals now, because it's one thing to violate a human resources policy, and if you violate a human resources policy, you could get fired from your job. You could be disciplined otherwise by your employer. Then you might or might not apply and qualify for unemployment insurance benefits. That's a whole other issue. You may have violated HIPAA. You could be in trouble with the feds for HIPAA violations, and your state licensure board could come after you. If you were a nurse and you violated HIPAA, you are putting your license in jeopardy. So the good lawyer thinks about all of those kinds of things happening at once. You know, you can throw in things like criminal stuff. I'm not really sure what criminal could evolve from this. You know, could the patient sue you for money damages and file a complaint with the state licensure board? Of course they could. So just think about all of the things that can happen to you. And when I worked with state licensure laws, you know, doing a bad root canal on a patient that fell below the minimum standard of care, for which you might receive a $500 fine and have to take a dozen remedial continuing education hours on how to do a root canal right, you know, that wasn't the biggest thing that could necessarily happen to a dentist. The fact that the patient would file a $100,000 lawsuit because they got a bad root canal that failed, that led to an infection, that blah, 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 you know, that was always paying a $500 fine to the state for doing a bad root canal was kind of a speeding ticket-ish level type thing, and the dentists were really worried about, you know, about patients sued me for $100,000 in damages. So think about how all of these things happen at once. Now, the title of this is social media, so let's get on to social media. We know about the basics of HIPAA requirements for patient records, that HIPAA is a federal right of privacy. There are state law privacy rights that existed before that, and that still exist now. You have medical confidentiality as found in state licensure laws, especially in mental health, but less in physical medicine such as physical therapy. There's very, very thin confidentiality mandates, very aspirational, physical therapy mandates in physical medicine, such as physical therapy, just as an example. You have medical confidentiality found in national and state codes of ethics. Those are usually non-binding state codes of ethics or national codes of ethics of organizations, not of state agencies. Codes of ethics are sometimes the titles of laws, like a city council code of ethics. Well, that's the law. That city council code of ethics is binding in city ordinance on the mayor's staff, city employees, members of the city council. But a code of ethics of the association of state city councils or whatever is not binding. Likewise, you have professional codes of ethics that are generally not binding unless they are specifically incorporated into state law. That's another webinar. You have employment policies and human resources manuals of employers that may contain standards, again, the remedy of which is you get fired. And you also may have state rules of evidence for privileged communications on what things are admissible and not. Hipaa effective, basically the core of it was done in April 2003. It applied to healthcare providers for protected health information for covered entities. Sometimes I slip and call it private health information, but it's really protected health information. Covered entities are you healthcare providers, clinics, facilities. It also covers independent contractors who are business associates of covered entities. This can even include a law firm that includes confidential medical records or things like that that contain protected health information. And of course, and this is important for fleshing out these social media violations, is that protected health information is any information held by a covered entity here that concerns health status, the provision of health care, or payment for health care that can be linked to an individual. It's interpreted rather broadly as to include any part of an individual's medical record or payment history. Remember, that can be linked to an individual, not is linked to an individual, but can be linked to an individual. And I will tell you, for a Hipaa violation, or if I was trying to prosecute a state licensure case, I would say that the fact that the patient found out that the post was about them did not only mean that that posting contained protected health information that can be linked to an individual, it was linked to an individual because they found out it was about them and hit the fan and called the hospital and complained to the board and blah, blah, blah. So, you know, there are specific definitions of protected health information. Any information, any form or medium that is created or received by a healthcare provider, et cetera, and relates to past, present, or future physical or mental health or condition of an individual. Doesn't that cover basically everything under those categories? There isn't any other concept of time besides past, present, or future, right? There isn't any other healthcare condition except things that you can divide into physical or mental healthcare conditions, or the provision of healthcare to an individual, or the past, present, or future payment for the provision of healthcare to an individual. Individually identifiable health information is health information that identifies the individual or with respect to which there is a reasonable basis to believe that the information can be used to identify the individual. We'll get to some examples of that later. Let's see, let's move on. Let's go on now, please. Let's move to 12. Okay. The basics of HIPAA requirements for patient records. Is there strict liability for a healthcare practitioner is posting individually identifiable health information that actually identifies the individual? If it actually does identify the individual, is there a presumption of having a reason for which there was a reasonable basis to believe that the information can be used to identify them? You know, think about generic statements versus specific statements that a healthcare practitioner could make. Anything in the way of a statement could form the foundation for a reasonable basis to connect the statement to a specific person. Not to ramble now and go into examples, but you know, it would be one thing for a nurse to say generally something like, really tough day at the hospital and emergency room today. I hope all my patients do well and get better, get well soon, as opposed to more specific things like horrific 3-car accident, that teenager's face was awful, went right through the windshield. You may be able to identify who that is, and we'll get to some specifics of that later. But with regard to an overview of HIPAA confidentiality with patient consent, you know patients can consent to the release of information. Implied consent involves things like insurance filings, billings, other kinds of things that are done. Express consent is for any reason or for no reason, or whether the patient just wants it. Consent can be delegated, such as providing records to an attorney of the patient. The patient can say, I want my attorney to have my records. I don't have to even tell you why. There are exceptions to confidentiality, usually found in mental health. Again, this is the subject of other webinars of mine, but such as treating a minor in a mental health treatment whose parents are involved in a contested child custody case. The child has a privilege that can be raised by someone on their behalf, like their treating therapist or an attorney guardian ad litem. Law enforcement exceptions apply. That's a term broadly applied to the government. Again, that's the subject of the webinar I did yesterday about law enforcement exceptions that I did for Compliance IQ. So can you waive your HIPAA privacy rights with a covered entity? Can you do that with a specific disclosure or media use by the covered entity, but only to that information used by covered entity and not with its employees and other agents? Those are all good questions. I don't know if I have the exact answer. But if you had a HIPAA privacy right that said, we'll use your name and or your image or photograph in any way we want in our advertising, in our newsletter, on our website, I don't know, I suppose you could consent to that perhaps, but I don't know why you would want to, or whether the hospital would be within its rights to say, either you consent to this or we're not treating you. That's kind of a novel question, one that's not really the subject of that, because all of this is about social media violations. That would be the topic for another day. We all know about social media and website features, all the way from the President of our United States who loves Twitter and tweets all the time, to young children who have the ability to look at Facebook postings, know how Twitter works, how to send a text message. We know about Facebook, LinkedIn, Twitter, YouTube, Instagram, various blog sites, social media sites that list healthcare professionals. There are doctor rating sites where people can rate their physician. By the way, lawyers who run blog sites are sometimes called running a blog, B-L-A-W-G, blog, like law blog, and I thought that was pretty clever that I saw recently. You also have, as I said, physician rating and other healthcare practitioner rating websites, kind of the TripAdvisor or Angeli's list of doctors and nurses. So I promised this was about social media violations, and here's some of the meat of this now. Healthcare professionals who post information and pictures about their personal lives, their families, and their work run the risk of social media violations. It's unique to healthcare as opposed to the general public because confidentiality is an issue for all healthcare practitioners. And social media is otherwise a valuable tool for patient education, for patient communications among groups, and the marketing of healthcare services. Social media is the source of common privacy breaches. Usually, but not all of them, the postings and such are well-intentioned or innocent actions that the practitioners never stopped and thought about could run afoul of their hospital policy, their licensure laws, or what have you. State licensure boards take an interest in patient confidentiality, especially in mental health. I suppose that nowhere else but in mental health and medicine would you want your therapist to have such strict confidentiality for keeping secret your hopes, desires, fears, dreams, and such like that you might tell a therapist. Let's see, an example of social media in a state licensure board case. This was a case I was involved in, and it's a public record. I won't name names, but there was a licensed physical therapist who treated a child who had a brain tumor. For more than a year, the child's mother had been posting updates and information on the child's condition on a personalized website for medical patients called, I don't remember which one it was, but one of the ones that exists in the world is caringbridge.org. Family and friends who had been invited by the child's mother could receive the information, post responses, and post messages such as good wishes and such. The physical therapist on her own private Facebook page posted, quote, "Please say some prayers for little Johnny. They just found out today his brain tumor is growing again. Poor guy has to get his central line reinserted and chemotherapy started again. Note, the Facebook page of the physical therapist listed her occupation as a PT, the health facility that employed her, and the department in which she worked providing physical therapy to patients. This is not like something where someone says, hey, I'm a physical therapist in the county. This listed her place of employment and the department for which she worked and the facility that she was employed by. How did this come to anyone's attention? Apparently not from the patient. The patient didn't complain. Somebody else did. A written complaint was filed with the State Board of Physical Therapy against the physical therapist. The child's mother had no objection, but the physical therapist's motives were pure, and the Facebook posting included information that was already made kind of semi-public by posting by the family on caringbridge.org or whatever website it was. But yet, you had to ask the question, did it matter if the information posted was the same, similar, or totally new and different than the social media information? I doubt the physical therapist was less clinical in the description of the specificity of this poor kid's growing brain tumor. Now, the State Board of Physical Therapy investigated and filed a written notice of an alleged violation of law. This put the physical therapist's license in jeopardy. They could have been revoked or suspended and lost their livelihood to practice. That was at least a possibility for a licensure law violation. There was a general privacy standard under that example under state law for, quote, having failed to respect the rights and dignity, quote, of the patient. That could have resulted in disciplinary action such as revocation of license, suspension of license, probation, reprimand, or a fine up to $2,000 per violation. So whether any or all of that was going to happen or should have happened or was necessary to happen based on the evidence is not what we're here about, but let me just say that was at least on the table, and when you're looking at that kind of thing, that gives you a pretty queasy feeling in the knees and in the pit of your stomach. Kind of like some of these maybe criminal laws that say, yeah, that's a 5 to 30-year penalty. Big difference between 5 and 30 years. Is it a little closer to the 5 or maybe closer to the 30? So that's what happened to this poor physical therapist, and now more of the story. Let's go. Okay, thank you. Slide 18 now. The State Board of Physical Therapy eventually dismissed the charges against the physical therapist. The state's regulations, those that I quoted you before, were vague and overly broad as a standard, and the posting of the family on social media negated the privacy violation. Now, by the way, when I say state regulation, these are not codes of ethics. They are not guidelines. They are not aspirational things. This was a state law that applied to physical therapists that said something like, you must, quote, respect the rights and dignity of the patient. Didn't say you had to follow Hipaa. Didn't say you had to keep information confidential. There wasn't very much in the physical therapy law about confidentiality, unlike, for example, state administrative regulation with regard to psychologists, not psychiatrists, but psychologists, have a 13-part, 13-subsection administrative regulation on confidentiality. So here you had kind of a broad painting with a broad brush. Just don't do anything to fail to respect the rights and dignity of the patient. Well, the state's regulations, they decided, were a bit vague and overly broad as a standard. The family had already posted this stuff, so how could you say, well, it violated the privacy or the rights and breached the sanctity of the doctor-patient relationship when the family had put all this stuff on their own Caring Bridge social media, even if maybe it wasn't open to the world, but maybe just 150 of their closest friends, relatives, families, neighbors, and classmates. Would this have been a Hipaa violation? I would say probably so, based on the Hipaa standards. The State Board of Physical Therapy in that case did not incorporate Hipaa standards in any way into its Practice Act under state law, nor were there other more specific confidentiality provisions in state law, only the general standard, quote, you must respect the rights and dignity of the patient, quote. However, and my colleague pointed this out, and that was that the physical therapist suffered the anxiety and cost of legal defense until dismissal of the disciplinary action. I think that was probably the right result there, but it got pretty far down the road where charges were filed. Physical therapists had to hire an attorney, get more information. You know, I'm sure it was very deferential at the time. That is, you know, can we point out to you, you may not be aware of this, but there's more to the story. Specifically, the patient's family had posted it and such like that. So, you know, let's go back to the quote here, because I just caution you very much about saying things like, please say some prayers for, and the name of the patient. His brain tumor is growing again. That's pretty clinical. Poor guy has to get his central line restarted and chemotherapy started again. That's pretty detailed clinically for something to post online and available to all of your 982 Facebook friends and maybe the world if you don't have your Facebook account settings appropriately limited. So that is an example of social media violations for a state licensure law. Remember, the physical therapist, you know, got a good result in the end, not a Hipaa result, but a licensure result, and they suffered the anxiety and cost of legal defense. More on social media, what could the board do differently? They could amend its law to apply to future cases to include some Hipaa standards or other confidentiality provisions. As I mentioned, there's a 13-part section in regulation that applies in this jurisdiction to licensed psychologists that covers confidentiality. You know, any interested party could file a Hipaa violation complaint with the federal government. The mechanics of that is beyond the scope of this webinar, how that goes. But, you know, it wouldn't even have to be the patient. Again, physical therapists suffered the anxiety and cost of legal defense until dismissal of the disciplinary action. So this is a little hard to read, but here's another one that was sure interesting. This is not about health care, but is an excellent example of what can be reasonably identified, because that's the part and parcel of the definition of protected health information, is the stuff can be reasonably identified, not actually identified or maybe identified, but reasonably identified. So we're going to go all the way from physical therapy to Hipaa to protected health information to Outback Steakhouse, where the headline screams, Outback Steakhouse waitress fired after complaining on Facebook that a church group left no tip on a $735 order. The Outback Steakhouse server was fired after complaining on Facebook. The 25-year-old had spent most of her shift putting together a 75-item order for a religious institution or church where she worked in Florida. Quote, we take the orders over the phone, we put the order together, take payment, and then take the order to the car. It's a lot of work just as much as serving. The waitress or server had said she made just $18 in tips during her shift that day, since she spent most of her time on the church's order of 25 steaks, 25 chickens, and 25 potatoes. I thought church groups would have something more traditional, like loaves and fishes. You just start with just a few of those, and if you have the right guy who is talented and miraculous, he'll turn those loaves and fishes into a full filling meal with baskets left over. But apparently this was not that level, and Outback Steakhouse made 25 steaks, 25 chickens, and 25 potatoes. She took to Facebook to complain that the Christ Fellowship had stiffed her on the tip, though she didn't identify where she worked. She said, I'm a waitress at a restaurant. Christ Fellowship never paid. No tip. But when a friend saw her post, he urged her to take it down and said he would contact Christ Fellowship directly to see if they'd remedy the situation. So he thought he was doing a good thing for the person and said, you know, I know the people at the church. This is small town Florida. I'll help straighten it out. Why don't you take it down? Well, the next day, the poor server came into work and was told that Christ Fellowship had been refunded the entire $735 and that she was fired. An Outback spokeswoman told the newspaper that the server had violated a company policy prohibiting employees from talking about customers online. The church said that they had contacted the restaurant after hearing the complaint from the friend about getting a tip to her, and they never intended her to be fired. The churches said that their policy is to tip carry-out orders, but the new volunteer wasn't aware of that. Lessons learned, reasonably identified information, a violation of the employer policy, and what happens in a small town when everybody knows everybody. So in the physical therapy example, you had a licensed physical therapist who named the patient by name. And even if they didn't name them by name, although they did, their Facebook employment listed where they worked, what department they worked at, et cetera, et cetera. It was awful easy to figure out who their patients were. So if you're a server in a small town, people might know you work at the Outback Steakhouse, and someone might say, hey, I know where that is. I know who that is, and the person ran afoul of the employer's policy about posting things, anything about customers. And I guess it works both ways. What if you praised the customer? The church left a generous tip. Blessed be who leave a generous tip from the church to a server. Would that get you in trouble if you said good things? I don't know. It might technically be a violation of the Outback Steakhouse social media policy for its servers and waiters. But, you know, the practical matter is if you said good things, how would anybody find out, and why would they be motivated to bring it to someone's attention? So you have other examples of social media violation with illicit gossip, breaches of privacy, or sometimes criminal liability that can include many other things besides Facebook. Describing patients vaguely but in enough detail that their identity can be determined based on the facts and circumstances. Posting videos or photographs that include patient faces, hospital room numbers, or portions of medical records. Recent news events have revealed those things. Sharing information by email or on social media with coworkers who are not involved in the patient's care, and commenting on other posts using protected health information or one's healthcare-related position as the basis for the comment. Before we leave the issue of reasonably identifiable, and that's not what this is all about, but it seems to be where people get caught on this, and this is not in the material, but I'll be focused in brief, or at least focused, if not brief. Went to a lawyer's ethics continuing legal education very recently out of town, paid for that to go to, it was worthwhile. And lawyers have a duty of confidentiality, and lawyers have to be very, very careful of what they post on Facebook because they can be deemed to violate confidentiality as well. So it's one thing to say, tough day in court, as opposed to tough day in court with an awful client. I told her she should have pleaded guilty, blah, 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 blah. She'll never get out of that bad murder charge for sure. Well, there may only be one murder charge. I hope around these parts of Kentucky there is only one murder case in an afternoon. You know, and people might read that on your lawyer's website or on the lawyer's Facebook page and say, hey, I know who that was. Why, you're breaching confidentiality by making a substantive comment that reasonably identifies the person or otherwise breaches confidentiality. So moving right along now, I do want to check the time. Okay, we're doing well on time. An overview of Hipaa as applied to social media can also include describing patients vaguely, as I said, but in enough detail that their identity can be known based on the facts and circumstances. Keep in mind how many small-town Americas there are where everybody knows everybody, such as a motor vehicle accident occurring. If you're a nurse in small-town Kentucky and work at a small-town county hospital and you post on Facebook or you send emails to somebody that says, terrible, terrible three-car motor vehicle accident over Friday night, boy, that teenager should have worn a seatbelt, her face was a mess. Even when the newspaper reports about that, when the newspaper reports about the wreck that happened on Monday, the newspaper will identify who was in the wreck. You didn't identify people who were in the wreck, but if the nurse is posting that on Facebook, it's not hard, people, to put two and two together, because in many small towns in Kentucky, there was only one three-car wreck that night. Might have been, thankfully, the only motor vehicle accident in the county that week that caused injury. And you better believe that in a small town where everybody knows everybody, when the newspaper reports on it, lists the people who were involved and injured and such like that, that when you post on social media something specific about your job, it absolutely can be connected right back to that motor vehicle accident. Here's another one that is so much more interesting. Posting videos or photographs that include patients' faces, hospital room numbers, or portions of medical records. Recent news events have revealed. The Associated Press back in February, I updated this just back in February at the time, of this year. Dental students at Yale took selfie with severed heads. Graduate dental school students and a top University of Connecticut orthodontics professors took a selfie with 2 severed heads used for medical research at a training workshop at Yale University last year. This was disturbing and inexcusable. The selfie was taken in June 2017, while that was already a year ago, at the Yale School of Medicine during a Future Leaders workshop which focused on dental-related facial deformities. The Associated Press obtained a copy of the photo from a person who received it through a private group chat, not Facebook, not LinkedIn, not Instagram, private group chat. It still went public. That was public enough. That person who demanded anonymity because of potential harm to their career said the person who took the selfie would not give the Associated Press permission to publish it for fear of being expelled. The people in the photograph included a doctor, an assistant professor of orthodontics, program director at University of Connecticut Health, and a visiting associate professor at Yale School of Medicine. In the photo, the doctor and several graduate students are looking at the camera while others continue to work. All are wearing surgical masks, and the 2 severed heads are on the tables face up. Interesting. One of the things that was kind of interesting about this was, I don't think I put this in the slide here, but you had a situation where the severed heads were visible in the slide or in the photograph, and when this originally hit the fan and was newsworthy and made the news, this was an article about an inappropriate photograph that did not include the photograph. One of the articles I read about this commented that we're writing this about this, possible breach of patient privacy and ethics because somebody took a picture, and we're not willing to show you the picture. Well, eventually somebody decided, we'll show you the picture after all, and they did show the picture, and so I actually have a copy of the picture, but, various faces are blurred out, including the faces of the deceased severed heads. So it was kind of a journalism issue as to whether it was appropriate to have an article about an inappropriate photograph and leave the inappropriate photograph to your imagination until it was actually indeed published later. The violation is a harm to the university and a harm to the public. This was similar to other cases of schools of embalming and funeral directing, which have strict policies and student codes of conduct with regard to treatment of dead human bodies. There was a case where a funeral home, a funeral director and embalmer in training in school was kicked out of the program for posting on social media, and you can imagine that the programs of funeral directing and embalming, as well as dentistry and medicine, rely on the goodwill of the public to donate their bodies to the School of Medicine. And if someone is posting about this on Facebook, it doesn't even have to be negative in a derogatory manner, like, let's say Mark the presenter donates his body to the School of Medicine. Somebody posts, wonderful to have such a smart dead lawyer, Mr. Mark, who was so wonderful to donate his body to the School of Medicine. That would be a violation, of a student code of conduct. It would get you kicked out of the university. If you were a dental student, it would be a Hipaa violation. But in this case, officials at Yale and University of Connecticut Health said the universities had taken steps to ensure it doesn't happen again. Yale officials said that they are improving oversight at such training events and making participants agree in writing to ethical standards of conduct. The chief communication officer said in a statement that UConn Health was made aware of the matter at the time it happened and took appropriate internal steps. Ask what those steps were. UConn Health does not comment on personal matters. The Yale spokesman said the School of Medicine at Yale took the matter very seriously. He said there was clear signage forbidding photography at each entrance to the lab. He also said the symposium was not part of Yale's anatomy program and the heads and the selfie were donated to Yale. So somehow cameras prohibited in the operatory did not stop someone from whipping out their cell phone and taking a selfie of them in front of the severed heads. And I love this line about the article. It was not clear how the heads were obtained. Really, I think they were obtained from dead bodies, don't you think? We could all agree on that. So let that be a lesson to you that the rules have to be clear, have to be enforced, have to be identified, and brought to people's attention. According to the article, there were signs that said no photographs. And why someone didn't adhere to that or think about it when they pulled out their iPhone or their smartphone and took a selfie. So beware, kind of the ultimate photo bombing, the dead severed heads that end up kind of in the background on the side left of a selfie. I guess that's what it was all about. So don't get me wrong, people. We're on slide 24, but I admire the healing arts as an attorney. In fact, I wanted to donate my own body to the local College of Medicine upon my death for scientific purposes, but I was actually rejected. And I said, why? Well, we only take complete bodies, and we know you're a lawyer. Lawyers, everyone agrees, are spineless, gutless, they lack a brain, and they have no heart. So for all of those listening today, you've been hearing someone who's not qualified by medical science to donate his body to the School of Medicine. Here's another one. A hospital technician in a small town involving a motor vehicle accident. While at work one day, the medical technician learned of an automobile crash victim and was brought into the ER. The technician later read about the crash in a news report online and posted it on Facebook. Again, kind of the example I used before. I was working today at the ER, should have worn a seatbelt. Because the city was a relatively small town, this was in a town named Jacksonville, but not Florida. There's obviously more than one Jacksonville across the country, and this was a small town, Jacksonville. The medical technician's comments went viral on social media, and the technician was terminated from her hospital job. The tech was probably just trying to remind people that seatbelts saves lives, but the comment was apparently seen by some as being callous or uncaring. People who work in healthcare need to remember that they are in a special position of trust, and their posts can be easily misinterpreted. Once posted, the comments live forever and ever and ever in cyberspace and cannot be retracted. Things posted on the internet are more permanent than a tattoo on one's body. I worked with mental health therapists who said they would tell teenage kids, they used to say, the most indelible permanent mark you can ever make on yourself is getting that big tattoo of a skull that your parents don't want you to get the day you turn 18. But they now say, posting something on the internet or that selfie of you drunk at a party will come back to haunt you maybe only as long as the rest of your life. Comments can live in cyberspace forever and ever. Healthcare practitioners are in a special position of trust. This could have been very much a healthcare HIPAA violation. Think about more of it as an employment violation. Was this a HIPAA violation? Could the comment be connected reasonably to identify it as a patient? Was it about a protected health information of the patient? The Facebook comment, again, this was Facebook, may not rise to the level of a HIPAA violation if or because no specific protected health information was disclosed. But the medical technician was terminated. Why? Based on the hospital's employment policies regarding social media. The related issues of social media policies by the employer can be more strict than HIPAA. You can dodge a bullet and not violate HIPAA, and you can be fired by your employer for violating their policy. Every healthcare employer should have similarly strict, concise, confidential, and social media policies. These should provide clear standards on the use of the hospital's information technology systems, as well as the use of personally owned devices while on the job. Don't even get me started about doctors and nurses who use their own smartphone to access work email and text and private email and texts. The policies that should be in effect in healthcare facilities and clinics and medical offices should cover employees, volunteers, the independent medical staff, contractors, vendors, and anyone else who may be viewed by the public as representing the hospital or its affiliated organizations. Now remember, the medical technician was probably trying to remind people that seatbelts save lives, but the comment was apparently seen as being callous or uncaring. Remember the special position of trust, and once posted, they can live in perpetuity. So let's talk about healthcare practitioner ratings websites. What are these websites? Again, as I mentioned earlier, think of TripAdvisor for healthcare professionals. Do doctors volunteer or pay to sign up in a directory? Are they operated irrespective of the participation of the doctor? Does the doctor have the ability to respond to patient comments and complaints? Can you cover this in a HIPAA waiver? an issue far beyond this 60 minutes we have together. Can the doctor have a patient gag policy that says, if you're my patient, you don't talk about me outside the clinic, and you specifically don't post things about me on social media? If you're not happy with me, you come and tell me I'm not happy with you, and I'll try to make you happy, or we can discharge you as a patient, but you don't go about speaking with me, speaking about me on Facebook and such like that. You know, is there a loophole there if you agree to that, but you quit being a patient of the facility and you then speak about it? I bet there are HIPAA gag policies and patient gag policies that could cover even that. You might have a HIPAA waiver if the patient violates the patient gag policy. Can the doctor respond to a patient's posting on a comment on a ratings website without violating HIPAA? Had a psychologist involved in a child custody evaluation in a family court divorce case, and he was court appointed. He was not hired by one of the parties. He was appointed by the judge as a neutral third person and fact finder to investigate and make a recommendation to the judge. The judge probably agreed upon a certain cost and then split it between the parties and say mom's lawyer pays half and dad's lawyers pay the other half. And the losing party, if you want to say that, the person who got negatively written about in a psychological evaluation, assessment, and recommendation was pretty upset with that and goes on one of those doctor rating websites, and the psychologist asks, can I respond to that? I don't think you can without violating HIPAA unless the person has waived their rights. And in fact, in that situation, they really weren't even a patient, although they were an examinee, someone that the examiner did have some duties to, but they weren't necessarily all of the duties of a patient. You know, one of the best comebacks for lawyers on confidentiality and for doctors on confidentiality is when someone badmouths them and I'm trying to think of an example here, you know, maybe a patient's complaint has gotten the lead of the local Mr. Fix-It newspaper. I'm not talking about Michael Cohen and the president, kind of the local community help columnist, you know, who might complain about a doctor and call the doctor and say, what's this about your bill? You know, that kind of thing like that, like a consumer protection issue. The best response for a lawyer who gets that kind of a call, the best response to a doctor is, you know, I would be glad to comment and spend time educating you on this situation, but the legal ethics or the medical ethics of my profession prohibit me from commenting on a specific patient. So I just can't talk to you about this. Goodbye. And if nothing else, I think that looks like a pretty good news report. That looks like a pretty good answer in the newspaper. Think about that as opposed to the kind of where the doctor is scurrying from the back door of her clinic, you know, and shoves her palm in the camera lens of the TV camera, you know, and says, no comment, go away from me, you know, that kind of thing like that, as opposed to a polite and true response that says the ethics of my profession as a physician require me not to respond to comments about patients. Every healthcare employer should have strict and concise confidentiality and social media policies, even though most employment is employment at will in each state. When we talk about employment at will, remember it works both ways. You can be fired at any time for any reason or for no reason or a bad reason, as long as it's not an illegal reason or a discriminatory reason. But remember, my quick tip about employment law is it works both ways. That is, you can quit anytime, any way, any reason, or for no reason. The fact that the clinic gives you a 50-cent an hour raise to be their receptionist is reason enough, and you don't even have to have a reason. But these kinds of confidentiality, employment manual and social media policies and human resources should provide clear standards on the use of the healthcare employer's information technology systems, as well as the use of personally owned devices while on the job. Like, for example, home health care workers who take their personal car on home health visits. Their job is to drive around the county or the city and make home health visits, and they get mileage for that, and they drive straight to their house at the end of the day. Again, policies should cover employees, volunteers, independent medical staff, or everybody. They should cover the use of social media on the job, the use of social media that mentions the employer, whether it's on the job or not, and other possible uses of social media that are not on the job and do not mention the employer, but can be traced from a specific social media user or person to employer, i.e. the white supremacist who posts inappropriate content online, you know, spewing Nazi-level vile that is disgusting even in an era of free speech and free ideas, and espousing the neo-Nazi white supremacist viewpoints, and somebody goes, oh yeah, I know that guy, you know, maybe his Facebook page says he works in healthcare or he works at the local hospital. That kind of thing will come back to bite you as well. The employer has the right to do with you what they want. So we've talked a lot about employment issues here and social media. I am watching the time now for this moment. The University of Texas MD Anderson Cancer Center has a social media policy as an example that talks about the use of social media while at work, where workforce members discuss, post, or share files or images or otherwise providing information on a social network that has come into their profession by virtue of their relationship with their employer, the Cancer Center. This employment policy defines social media or social network as an online platform where individuals or groups interact and share information or share with others. Remember, private employment policies can exceed HIPAA requirements. Also note patient First Amendment rights to free speech when employed by a government healthcare entity, such as a county hospital or state university medical center. However, when it is job related, you have less of a right of free speech. You don't have a greater right of free speech just because you are a state worker. So a county hospital nurse has a First Amendment freedom of speech to write about gun control and Second Amendment rights and you know, how awful the capital punishment is in this state or whatever, or what a disgrace the criminal justice system is, or whatever they want to rant and rail about. They've got a free speech to that, but the government, the county hospital, can crack down on that, whistleblower exceptions notwithstanding, but the state county hospital, the county hospital or the state university hospital or medical clinic can crack down on that when you're talking about things that are within your bailiwick, within your healthcare setting, within your employer. So it's one thing to have a First Amendment right about the death penalty, about taxes in the county, or the way government is working, or retirements on the U.S. Supreme Court, but it's another thing when you criticize your own employer and they can come after you for that. There's less, if no, First Amendment right of protection to that kind of stuff. We're trying to round third base here, and we're in the home stretch. That mixes a baseball and a horse racing metaphor, so I apologize for that. Examples of violations of the social media policy of an employer can include these things: posting a video or a photograph mentioning a patient by name, posting a diagnostic image that contains a name, medical record number, or date. Example, expert witness physician within a med-mal case who published a, quote, redacted radiologic image in a recent medical journal or handbook where, like, the patient name and date of birth were redacted. But the same radiograph was in their publication, in an online publication and in book form, and all this other information was identifiable because the name and the date of birth may have been blacked out by the editor or the copywriter, but there was a date code, a hospital name, a date the radiograph was taken, the department that it was taken in, and people were able to put two and two together as to who that patient was, and the reason why they were able to do that is the patient had filed a medical malpractice case. So, you know, blacking out the patient's name and date of birth, but leaving other identifying information, the hospital, the department of the hospital, the date the image was taken, a male or female or whatever was more than enough to hook that individual and get that expert witness in trouble. Also describing a patient encounter with enough specificity to identify the patient or someone who knows the patient or would know who is being referred to. Also responding to a post or public message from a patient with additional details about their health situation. So do not post pictures or other patient information without express patient consent. The fact that a patient or a family member has already posted something about the situation does not constitute valid consent. You know, mental health professionals seem to know it. Just because somebody has made a public announcement or something like that does not mean that you have a right to confirm that as the patient's therapist, one way or the other. Don't gossip about patients. Even if you try to anonymize a patient's identity, people who know the situation can figure out who you're referring to. Do not post something online if you would not talk about it in the hospital cafeteria or elevator. Do not forget that everything on social media is public and seems to last forever. Do not use your work email address for personal social media activity. And don't forget that on a personal social media account, you are speaking for yourself and not the organization. I have another anecdote here, but I'll go comment. Let's skip that. Let's do common suggestions for the employer. Have an interdisciplinary team review your employment policies related to confidentiality, social media, and related topics. Include representatives of corporate compliance, legal, IT, HR, risk management, finance, other departments. Apply the policy to the entire workforce, not just healthcare practitioners. Do recognize that in addition to HIPAA, policies must address state laws, other mandatory rules, and applicable professional codes of ethics. Do have a single individual named by title responsible for overseeing the social media policy, and do conduct ongoing, frequent education and communication about HIPAA, patient confidentiality, and the dangers of the inappropriate use of social media. State licensure boards and agencies may apply violations of confidentiality to protected health information, state laws as applied to licensed healthcare professionals. You probably don't have much of a privacy interest. It's not terribly confidential to have a root canal, but I'm telling you, I've seen enough root canal records to know that medical histories of patients have the most private information. Sexual history, current medications, current medical records of current procedures may also be very confidential, like giving current medication information. Yes, so what, I had a root canal, that's why I was gone for half a day of work yesterday, but holy smokes, no one needs to know that I got a 5-day supply of oxycodone or hydrocodone. Notice where there are generic laws where HIPAA is never mentioned, but that could apply, like how generic state licensure laws may implicate HIPAA, and no HIPAA sanctions for violations to occur. Seems like I had an anecdote, but I'm going to skip over that. State licensure laws like professional codes of ethics and the concept of confidentiality should be firmly ingrained in the healthcare professional psyches and work habits. Social media is still kind of relatively new, and it can be used to great effect to enhance the organization's visibility and provide patients with better info, and when used as official communication of the healthcare entity. But when misused, social media also carries legal risks that could negatively affect the organization and result in personal consequences for the individuals and job. It's the most common consequence seems to be losing your job. HIPAA violations could follow, as well as state licensure laws. So we are right at 60 minutes from when we hit go. What have we covered today? Basics of HIPAA, privacy violations and social media, employment and human resources violations involving social media, and state licensure laws as applied to HIPAA, privacy violations, including and involving social media. Top takeaways, HIPAA is not new. Everyone should be involved with HIPAA on a day-to-day basis and get it right. Confidentiality is not new, especially in mental health. State licensure laws of healthcare professionals, they're not new either, but these contain the most basic of mandates that can now be violated in new ways via social media. Social media is somewhat new. Personal disclosure is getting pretty routine in our lives. People write about anything and everything. Employment agreements and human resources manuals are getting more and more concisely worded as the law has more clearly favored employer controls over social media of their employees. This goes beyond mere HIPAA, and it always favors the employee in an at-will state. We have reached the end. It's 1 minute over. We paced ourselves like an Olympic trials athlete. There is still time for questions and answers if anyone wants to stay on and ask those. Because we take questions by typing, we will leave a number of moments of silence for everyone to have plenty of opportunity. As I'm looking and monitoring our webinar here, it's a great pleasure to tell you that not only did we have at least a record or near record number of people, we have a near record number of people who made it through and are still on the line. So thank you all for your patience, and I do want to leave as much time as everyone is willing